You're driving home. Nothing wrong. Seatbelt on, speed legal, registration current, red and blue lights flash behind you. You pull over calmly because you have nothing to hide. The officer walks up to your window and in a casual, almost friendly voice asks 4 words. Where are you coming from? And right there, before a single document is exchanged, most people hand over everything the officer needs to extend that stop, build suspicion, and potentially search their vehicle. Every single day, drivers across this country make one critical mistake. They answer that question. They think it's small talk. It's not. I've spent years studying police procedures, body cam footage, and constitutional case law. I've reviewed hundreds of traffic stop cases where that single question, where are you coming from, triggered an extended detention, a search, and in some cases an arrest. Today I'm going to show you 5 specific mistakes drivers make when an officer asks that question, and I'll give you the exact words to say instead. Number 5 may be the most dangerous mistake of all. This is educational content to help you understand your rights. For specific legal advice, talk to an attorney in your state. Mistake number 1 is answering the question at all. Here's what happens in real stops. Officer, where are you coming from tonight? Driver, oh, I was just at a friend's house over on the east side. Officer, what were you doing over there? Driver, just hanging out, having a couple beers. I mean, I didn't drink much. And just like that, that driver has handed the officer a suspicion of DUI on a silver platter. They started talking and couldn't stop. Here is what officers are trained to do that they don't put in the brochure. Before any confrontational questioning begins, officers are taught to establish what interrogation trainers call a behavioral baseline. They ask you casual, low-stakes questions. Where you're coming from, how your night was, where you're headed. Not because they care, but because your answers and your demeanor while answering become the measuring stick for everything that follows. If you seem nervous answering the casual question, they use that. If you hesitate, they use that. If you say something that doesn't match what they expect, they build on that. The body cam is rolling the entire time, capturing every word, every pause, every expression. That footage doesn't just document the stop. It becomes evidence. The correct move here is not to answer. The exact words are, Officer, I'd rather not answer questions. Say it calmly, say it politely, no attitude, no lecture, just a clean, firm statement. Why does it work? Because you are not required to answer questions beyond providing your license, registration, and proof of insurance. The officer is asking. You are declining. That is your right. Remember, Officer, I'd rather not answer questions. Stay calm, stay polite, but stay firm. Cooperation does not mean conversation. The less you say, the less evidence exists on that body cam footage. That stops you from handing over the behavioral baseline they want. But here is the legal gap that catches almost everyone who knows this first principle. Refusing to answer in general is a good start, but what if you accidentally answer just a little? What if you give them a location? Courts have ruled that a single piece of location data can become a legal building block. That's mistake number 2, naming a location. Picture this, Officer, where are you coming from? Driver, just the gym. Officer, which gym? Driver, the one off 5th and Main. Officer, that area's had a lot of car break-ins lately. You live around there? And now you're 4 exchanges deep, building a profile the officer can use. You've identified your location, your familiarity with the area, and confirmed you were near a known trouble spot. The reason people do this is because a location seems innocent. But the Supreme Court addressed exactly this dynamic in Illinois versus Wardlow in 2000. The court ruled that while being in a high-crime area alone is not enough to create reasonable suspicion. It is a relevant factor in the totality of circumstances analysis. What that means for you: if you name a location the officer considers problematic, that information becomes one tile in a mosaic they are building in real time. Body cams capture every word, and a prosecutor can later argue that your stated location, combined with other factors, your nervousness, the time of night, the area's crime history, contributed to reasonable suspicion for detention. The exact words to use instead: "Officer, I invoke my right to remain silent." Say that clearly, not a shrug, not silence. Those words specifically. Because as we will cover in mistake number 5, silence alone is not legally protected. You must say the words: "Officer, I invoke my right to remain silent." Your tone should be calm and respectful, not hostile. This is about legal protection, not confrontation. Bottom line, never give them a location. Any location can become a legal building block. That protects you from the location trap. But here's a constitutional gap most people don't know exists even after they learn that principle. Invoking your right to remain silent covers future answers. But what about what you've already said? Courts have found that prior voluntary statements made before invocation can still be used. And the place those prior statements get created is mistake number 3. Volunteering details or telling an inconsistent story. Scenario: the officer asks a follow-up after your first answer. Officer: so you were at a friend's house? How long were you there? Driver: maybe a couple of hours. Well, actually, I got there around 7, so more like 3 hours. Officer: what did you do the whole time? Driver: just watched TV and talked. Officer: anybody else there? Driver: just my friend. Well, a couple other people stopped by. Federal court records reveal a consistent pattern. In cases like United States versus Whitley in the Sixth Circuit, courts have noted that inconsistent or evolving travel explanations, even seemingly innocent ones, are one of the most frequently cited factors when officers justify extending a stop. Why do people do this? They think clarifying helps. They think being friendly diffuses the situation. They are wrong. Officers are trained to ask follow-up questions specifically to find inconsistencies, and then use those inconsistencies to argue reasonable suspicion. The body cam is recording all of it, every correction, every hesitation, every revised detail. The correct move once you have already said something: stop immediately. The exact phrase is still: "Officer, I invoke my right to remain silent." If you said one thing and realize you shouldn't have, do not try to fix it by saying more. Every additional word is potential additional evidence. Stay calm, stay polite, but go silent. Now, bottom line: the moment you start talking, every correction makes it worse. Stop, invoke, and stay there. You've now learned that answers, locations, and inconsistencies all feed the case against you. If you're realizing this goes deeper than you thought, hype this video right now. This is exactly the constitutional knowledge people need before their next stop. Now here's where it gets even more critical. Mistake number 4 is behavioral data. What your body does while you're answering. This one operates in the background, and most people have no idea it's happening. Officer: where are you coming from tonight? Driver: just from a friend's place. And while the driver speaks, the officer is watching. Are the hands shaking? Are the eyes moving around? Is there a dry swallow? Is there fidgeting in the seat? Is the voice slightly elevated? Officers are taught through the behavior analysis framework used in training programs across the country to establish a baseline with casual questions and then compare everything that follows against that baseline. The FBI Law Enforcement Bulletin has documented this approach. Interviewers develop rapport and establish baseline behaviors during early, non-threatening conversation. Then watch for deviations. The body cam captures behavior as well as words. Prosecutors can call the officer to testify about what they observed: your nervousness, your hesitation, your physical response. And courts have allowed that testimony to factor into probable cause determinations. This is why the instruction is not just to say the right words, but to stop the verbal interaction as quickly as possible. Every exchange you engage in is another data point being cataloged. The exact phrase remains: "Officer, I invoke my right to remain silent." Calm voice, hands visible, no sudden movements. Your tone matters as much as your words. Both the officer's body cam and your own recording capture all of it. Bottom line, even your body language is evidence when the camera is rolling. That behavioral protection is critical. But here's the constitutional gap that trips up even people who've done everything else right. You stayed calm, you limited your words, your body language was controlled. And then the officer asked another question and you just went quiet. You said nothing. You assumed silence was protected. And that is mistake number 5, and it may be the most dangerous one on this list. The Supreme Court decided Salinas versus Texas in 2013, and the ruling is one of the most important and least known decisions affecting everyday drivers. Salinas voluntarily answered questions, but went silent when asked one specific incriminating question. He never said he was invoking his Fifth Amendment right. Prosecutors used that silence as evidence of guilt. The Supreme Court ruled 5-4 that the silence was not protected because Salinas never formally invoked the privilege. What that means for you at a traffic stop: just going quiet is not enough. Silence alone is insolubly ambiguous, as the court put it. You could be staying quiet because you're guilty, or nervous, or thinking, or protecting someone. The Fifth Amendment does not automatically protect unexplained silence in non-custodial situations. You must say the words. The exact phrase: "Officer, I invoke my right to remain silent." Say it out loud. Say it clearly. "Officer, I invoke my right to remain silent." A third time, so it locks in. "Officer, I invoke my right to remain silent." That is the phrase that creates the legal protection. Not a shrug, not a pause, not looking away. The words. If the officer keeps asking questions after that, you do not answer. You have invoked. Repeat the phrase if necessary. Stay calm, stay polite, but do not answer. Bottom line, under Salinas versus Texas, silence without invocation is not constitutionally protected. Say the words every time. Now let's talk about what you do with your body and how to handle the officer's approach before a single word is exchanged. The first 30 seconds of a traffic stop set the tone for everything that follows. Here is the physical safety protocol. Pull over promptly using your turn signal. Turn on your dome light if it's dark outside. Turn off the engine. Place your hands on the steering wheel where the officer can see them. Lock your doors. Roll your window down only 2 to 4 inches, enough to pass documents through. When the officer approaches, announce, "I'm going to retrieve my documents from the glove compartment. My hands will stay visible." This controls the physical environment, limits the officer's claim of plain view observations, and demonstrates cooperation without vulnerability. Now, one of the most important distinctions to understand during any traffic stop is the difference between a request and an order. If an officer says, "Step out of the vehicle," or "Open your trunk," your first question should be, "Officer, are you asking me or ordering me?" If they are asking, you can decline. If they are ordering, you must comply. But before you do, say this. For the record, what is the lawful basis for that order? Then comply and add, "I am complying under protest and my hands will remain visible." This creates a documented record of non-voluntary compliance, which matters if you later challenge the encounter in court. One more thing you must understand: police can legally lie to you. Under Frazier versus Cupp and consistent court precedent, officers may falsely claim they have evidence, that a witness identified you, that a co-passenger already talked, or that cooperation will help you. None of this has to be true. There is one exception. They cannot fabricate actual physical documents, but verbal claims? Fair game under the law. This is exactly why you never answer questions without an attorney present. Stay calm, stay polite, but stay firm. Be respectful, not talkative. Understanding what type of encounter you're in changes everything. There are 3 legal categories of police encounters. First is a consensual encounter. The officer approaches and asks questions. You are free to leave at any time. You have no obligation to answer anything. The question, "Am I free to leave?" establishes whether you are in this category. If the answer is yes, you may calmly walk or drive away. Second is a Terry stop, also called an investigative detention. Based on Terry versus Ohio from 1968, officers need specific, articulable facts, not a hunch, to briefly detain you. During a Terry stop, they may pat down the outside of your clothing for weapons only, not drugs, not your belongings. The stop must end when the purpose is resolved. Under Rodriguez versus United States, decided in 2015, officers cannot extend the stop beyond its original mission without independent, reasonable suspicion. That 7-minute dog sniff the officer wanted to add? Unconstitutional without more. Third is an arrest, which requires probable cause and triggers full Miranda protections. You are rarely told which category you are in. That is intentional. So you ask, "Am I free to leave?" Now, state law matters here, and it varies significantly. About 24 states have stop and identify statutes. If you are lawfully detained in states like Indiana, Florida, or Nevada, you may be required to provide your name or show identification. In California, you are not required to identify yourself during a consensual encounter. In Texas, if lawfully detained, you must give your name, date of birth, and address. The marijuana smell question also varies. In Colorado and Maryland, odor alone is not sufficient probable cause for a search. In Texas and Ohio, courts have ruled that smell alone can still establish probable cause. Know your state's rules. These variations are why the phrase, "Am I free to leave?" is always your first move. It determines which legal category applies to you right now. Here is the core principle that ties everything together. A traffic stop is a legal investigation, and anything you say voluntarily is evidence. Now commit these 4 phrases to memory. First, "Am I free to leave?" Say it early. It establishes your legal status and forces the officer to either end the encounter or justify the detention. Second, "I invoke my right to remain silent, not silence." These words. Based on Salinas versus Texas, unexplained silence is not protected. You must say it out loud. Third, "I want an attorney." This ends questioning legally, even before an arrest. You can invoke this right at any point. Once you say it, the officer must stop asking questions until counsel is present. Fourth, "I do not consent to any searches." A shrug, a hesitation, or an unclear response can be treated as consent. The statement must be unambiguous. Say it clearly, "I do not consent to any searches." This is constitutional knowledge that belongs to every driver on the road. If this video educated you on rights you didn't fully know, hype it right now so it reaches someone before their next traffic stop. That's how this information spreads. Write these 4 phrases down. Practice saying them in a normal, calm voice. Put them in your notes so they're accessible under pressure. You can be cooperative and still exercise your constitutional rights. Stay calm, stay polite, and stay firm. Remember, this is educational content only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. You now have the legal framework to face that question. Where are you coming from? And protect yourself every single time. Like this video, subscribe to the channel, hit the bell so you never miss an update, and share this with someone who needs it. Drop a comment telling me where you're watching from and what time it is right now. And remember, the Constitution is not just a document, it's your shield. Use it.